My experience with state employees are that they are honest, overwhelmingly honest. People don't try to hide things. They're not up to no good.
People may have complete trust in you, but they have the right to go back and verify what you've said.
The future of public records in Kentucky in question after a state Supreme Court ruling this spring.
This could very well be the end of the law as we know it.
At the core of the issue, where do you draw the line between personal privacy and public business? The justices in rare public comments on a case offering differing opinions on the topic.
I don't think that the employer gets to go to an employee's private cell phone. It's just an invasion of privacy.
We all have our personal right to privacy. We don't ever give that up. But when we serve the public, we do so with the expectation that the public is going to expect of us to provide them information to explain our actions.
This month on the Crossroads Suncast, transparency versus privacy.
Government transparency and accountability are issues that unite both ends of the political spectrum.
If we're going to have a democracy, if we're going to self-govern, we have to know what our government's doing.
What open records law really is, why it matters, and what the future looks like in Kentucky. I'm Morgan Regal.
We've been around almost 50 years doing research and education and access to public records.
That's David Coulier. He works with the University of Florida Breckner Freedom of Information Project.
We coordinate National Sunshine Week to educate the public in their right to know. We track legislation all across the country and all states regarding this. And we do advocacy and research just anywhere in the country that needs it.
He says public records law is nothing new.
Massachusetts had one in the 1860s. There were probably 15 or 20 before 1950. So, but around the 70s, they really took off. A lot of them got revamped. It was mostly in response to Watergate and civil rights era and all the kind of interest in government accountability.
So let's get to this particular case. It all starts with a man named Brian Mackey. In 2021, he files an open records request with the Kentucky Department of Fish and Wildlife Resources Commission to look at public records, including text messages. Some of his request is granted, but not all. The commission denies his request to obtain text messages stored on the private devices of commission members and the commissioner. That's when Amy Bensonhaver and the Kentucky Open Government Coalition gets involved.
And he and I had several conversations about this in which I expressed with absolute certainty that there was no distinction between communications on a private device or account and communications on a public device or account.
It's important to note these were volunteer positions and they were not provided a government-issued device. More on that later. Mackey actually drops the appeal, so the Open Government Coalition picks up the case, filing the same open records request, getting the same answer as Mackey did. As their name implies, this kind of advocacy work is right up their alley.
Other than the elected officials themselves, who deeply resent the law and would do their utmost to undermine the law, people on the far left, people on the far right, and virtually everybody in between understand that these laws serve the public, are important to the public, and must be preserved.
The case eventually ends up in the State Court of Appeals, and it largely sided with the Open Government Coalition. Here are the key holdings. Number 1, text messages can be public records even when they're stored on personal devices. The court held that the location of the record does not matter, especially because personal device use was unavoidable because the commissioners were not given agency email accounts or devices. Number 2, the court rejected the idea that all texts on personal phones are exempt. Number 3, the Court of Appeals disagreed with the trial court about undue burden. Essentially, that lower court ruled searching private phones would be an unreasonable burden. The Court of Appeals held that it must be proven on a case-by-case basis. And lastly, it did, however, determine that the Kentucky Department of Fish and Wildlife Resources Commission did not act willfully and did have a legal basis for its position. Wednesday, September 10th, 2025.
This court is now in session. God save the Commonwealth and God save this honorable court.
Thank you. You may be seated.
The state's High Court meets at Center College in Danville to hear oral arguments after justices agreed to take up the case. All the audio you're about to hear courtesy of KET's online archive of state Supreme Court oral arguments. First up, Jan West, counsel for the Fish and Wildlife Commission.
Basically, the first issue is whether the communications constitute public records as defined by the Act, and the second issue is if they do, whether these records come within two exceptions. Whether it would be unduly burdensome to produce them, or whether it would be an invasion of privacy to require the members to potentially turn over their phones for inspection to determine whether the records are responsive.
It's pretty clear right off the bat where some of the justices stand already based on the questions they're asking. Justice Kelly Thompson represents Kentucky's 2nd District in the Supreme Court. Listen to this question he poses to West.
Well, when they ask for every communication between Mr. X and Mr. Y, that is a very overly broad invasion of their privacy interest. Am I right?
Yes, you're right, and that's what we believe, and that's what we argue.
Now listen to this exchange he has with Michael Abadi, counsel for the Kentucky Open Government Coalition.
There's a description of what records can constitute. I agree with you, that's fluid, but there's a specific description of what constitutes a public record. First, it is in the possession of the agency. Are any of these records in the possession of this agency?
Well, there's a number of things.
Or retained by a public agency. Are any of these records retained by a public agency?
Our argument, Your Honor, is records are either prepared or used, which are two things on that list. If two commissioners are texting about the public's business, and they prepared that in their role as a commissioner.
Do you have information they were discussing public's business relating to your complaint on their cell phones? I'm looking at this like a search warrant. You're wanting to search their phones.
No, we are not, Your Honor.
To sum it up for you, West essentially argues that these were volunteers, meaning they weren't employed by the state, and they weren't issued government devices or accounts to have conversations on. Abadi, on the other hand, argues that it doesn't matter if the records are in a filing cabinet or a cell phone, they're still public records that belong to the people, no matter who obtains them or where they are held. We'll let you hear closing arguments from both sides, starting with Abadi.
In conclusion, we understand the balancing that is at issue here, but the way to appropriately deal with that is to reflect we are not asking for some absolutely invasive search of cell phones. We are asking that those records be treated the same way as every other system of records that has to be searched today. And all of these issues about what's at the margin, what might be responsive, what happens if somebody won't comply in good faith, those can be sorted out in appropriate cases down the road. But if this court were to use those concerns to say these records are never subject to the open records law, we know what's going to happen, and it will be the death of transparency.
West cites a similar case at the federal level in her closing statements.
The request was for text messages on federal employees' personal devices, and the court refused to require those to be turned over, where the requester did not point to any evidence indicating that the text messages were used for agency business or otherwise show that searching text messages would be likely to lead to responsive documents. So I think if that makes a lot of sense. If you were to even lean in the direction of requiring that there must be some evidence shown that there were such documents that would be unacceptable.
The hearing concludes after 52 minutes. The two sides would have to wait 225 days before a ruling is announced. April 23rd, 2026.
The court ruled that emails and texts on public officials' private devices are not public records under the Kentucky Open Records Act, even if they conduct or concern official business. Individual board members, they said, do not qualify as a public agency.
I was gobsmacked. I had never conceived that this could happen.
The state's high court votes 4-2 in favor of the Department of Fish and Wildlife Resources Commission. One justice recused herself. Justice Kelly Thompson, who you heard from in the oral arguments, writes the majority opinion. Justice Shay Nickel, representing District 1 in Western Kentucky, writes the dissent. It's rare you hear justices comment on cases after the fact. In this one, both Thompson and Nickel spoke to me about their decisions.
To me, it was the volunteer status that really influenced me. If we take all of the state of Kentucky employees and all of the volunteers who volunteer to help the state of Kentucky, and we order access to their private cell phones, that will be a tremendous inconvenience. There was no practical way to look into private cell phones, and why would we order it if there's no way to do it?
Here's Justice Shay Nickel.
I think there is a misperception among some, and perhaps even had an impact on some of the justices who voted with the majority here, that the Open Records Act, if applied towards private devices, electronic devices, would open the door to the courts seizing your cell phones or your computers and going back and going through all of your thousands of communications to discover particular government-related or agency-related information. But in fact, the Open Records Act has always depended to a great degree upon the good faith of the participants in our government and our agencies, even volunteers. I think the majority made some distinction here that these were volunteer actors. But whether volunteer or paid, if you're doing the public's work, then then any records related to that work, based on my reading of the act, should be subject to public scrutiny to determine how you arrived at a decision.
That good faith argument that Justice Nickel makes is something I asked Justice Thompson about.
Apparently, he doesn't believe in the honor system, and a big group of people don't. They think that state government employees and state government volunteers are up to nefarious activities, and that they're going to hide things in their personal cell phones. They're going to hide government records. I have a presumption that everyone is honest and doing a good job. If we were to find someone who was hiding public records in an attempt to circumvent the open records, then there would be a separate cause of action with allegations specific to them, and you could get their records. But to presume that there's at least 50,000 cell phones we're talking about here, 50,000 personal cell phones. What if your employer asked you to look into your cell phone and give information from your private cell phone to them because a third party wants access to their phone, to the records in their phone? And the honor system, it's a toothless order. We want to see your cell phones. Now, it's up to you to give them to us or not. No, these are records not in the possession of any governmental agency. This is snooping into private people's cell phones.
Justice Nickel believes personal privacy does have some limits when you're in the public eye.
I do think, we need to protect public servants. You don't surrender all of your constitutional rights when you take on a public role, but you do take on the responsibility of answering the public when they have questions. And sometimes to go back to a statement that President Reagan used to say, trust but verify, which is an old Russian proverb, actually. Um, the people may have complete trust in you, but they have the right to go back and verify what you've said. And if you're being transparent and honest, you should have no fear to do that.
Once the state Supreme Court decides on a case, it's pretty much final. Both sides note that this isn't the type of case the U.S. Supreme Court would take up because it's pretty state-specific. What was an option, though, a motion to reconsider. Since the vote was 4-2, all the Open Government Coalition would have had to do was flip one justice's vote. If it was a 3-3 tie, the decision would have gone back to the Court of Appeals, which largely favored the coalition's stance. My colleague Ben Overby with the Paducah Sun asked the body why he chose not to make that motion.
I guess what I would say is there was a very rigorous debate between the majority and the dissent in the opinions, and everybody cast their votes. There's no right of further appeal, and filing a motion to reconsider is a very rare thing in the Court of Appeals or the Supreme Court. It's almost never successful, and in particular, in a case where there had been dissent and all the arguments had been aired and the justices cast a vote one way or the other.
We asked the Counsel for Fish and Wildlife, Jan West, who's a Mayfield native, if the decision not to came as a surprise.
I thought they might. I mean, I was a little surprised they didn't, yes. But, really wasn't sure what they would do.
Since the decision nearly 2 months ago now, open rights advocates have sounded the alarm about potential impacts this ruling could have.
This was really out of whack with the basics of democracy and knowing what our government's doing.
Both Coulier and Justice Shay Nichols say this decision could have a trickle-down effect into politics in the state.
Kentucky U.S. Justice Brandeis famously said sunlight is the best disinfectant. And what he meant by that was that the more information the public has in grading, if you will, their government officials and decisions made, the better government will be, the stronger it will be. And particularly today when there's a national, today when there's perhaps a crisis in our nation and our commonwealth and even in our individual communications regarding trust, the more transparency there is, the more information is available for people to weigh and make their own decisions. I think the better. It makes us all stronger.
What I've learned through this reporting process is both sides say there's more nuance to this ruling.
Maybe the judge is saying if the records officer has to go through the person's phone, they're going to see private messages that'll invade that person's privacy. All right, that's a fair point. Depending on how personal someone, communicates on their phone, some people in very personal ways. But you know what? If you're a government official, particularly a high-level elected official, you learn to be careful what you communicate on any device because you know that it can get out, and you don't want that on the front page of the Post-Dispatch or wherever, right? So I think it's not really a strong argument because the public's interest in knowing the government's business outweighs that privacy interest. And that's what we have to balance here.
On the other hand, attorney for Fish and Wildlife Jan West says the decision isn't as bad as the other side is making it seem.
I think a lot of people don't focus on the fact that really this decision applied to board and commission members. You've got lots of state employees and other people who are employed by the state that the court, in my opinion, did not apply this decision to. It was only, in this case, the board and commission member. So I think in some cases, maybe people are maybe overreacting a little bit because they're thinking, well, every person that's involved with state government is affected by this decision, and really they're not.
Even counsel for the Open Government Coalition, Michael Abadi, acknowledged that in an interview with us.
So, I think some of the reporting has suggested that this means these kinds of records are off limits forever. That's not what the opinion actually says, and I think over time we will see how it plays out.
The main takeaway that pretty much everyone acknowledged: open records law is fluid, and what happens in the future remains to be seen.
It can be amended at any time. It can be changed at any time. It can be repealed at any time by the legislature.
Justice Nichols says he expects this to come back up again in the future.
I don't think this is the final decision that's going to forever carve out what exactly the legislature intended when it passed the Open Records Act. I think future cases will continue to clarify that, and certainly future legislative action, the decision among the legislators to come back and to review the majority opinion in this particular case, to grade the paper, if you will, of the dissent.
But Benson Haver isn't holding out hope that action will be taken to clarify the ruling.
I'm not sure where anybody gets the notion that the legislature is suddenly going to become open records friendly. In general, everything they've done is to undermine rights. The residency requirement, excluding themselves from the open records law, introducing new exceptions that are entirely unneeded, but more importantly, complicate and confuse and lead to all sorts of unfortunate outcomes.
Reporting with me on this episode was Paducah Sun reporter Ben Overby. Find his reporting on paducahsun.com or in this weekend's Weekend Edition. Video and audio by Chief Photographer Mason Watkins. Editing by Brian Clapp. Thanks for listening.